on a banker's guide to a successful workout. Today's topic is initial steps to take when a loan is transferred to workout. As most of you know, and those of you who have not had a chance yet, normally when a loan is transferred to workout, it's almost akin to being in the emergency room, and you're the emergency room doctor as the workout officer, where the patient comes into the emergency room and is bleeding, and there's all sorts of issues, and there's a lot of noise, there's a lot of issues coming in with this borrower or within the credit, and the question is how do we resuscitate the debtor, how do we resuscitate the patient, so to speak, and before really you can do anything, just like an emergency room doctor when a patient comes in with trauma, doesn't just go ahead and operate, he or she does their due diligence in making sure that the patient doesn't have any allergies to anesthesia, that any operation they do won't do any further harm. So too, when a loan is transferred to workout, it's very important that certain due diligence and precautionary measures take place before you do anything with the credit, take any action, and sometimes that is very hard to resist because of the noise that normally comes with a credit being transferred to workout. Normally there is a lot of pressure to get moving, to stop the hemorrhaging of cash and of other issues with this distressed borrower. But one of the things we are going to try to go over here initially is that there are quite a few steps you want to do to ensure that you are not making the situation any worse and giving the bank the best possible chance to recover fully from the credit. So one of the first things you do that a credit officer should do when a loan is transferred to workout and get this file is the first thing you need to do is go through and organize and audit all the loan documents that are in the file. Now granted, you will probably in many situations be hiring counsel who will be doing a deeper dive into the loan documents. We think best practices is that the workout officer should also have a working knowledge of the loan file, because as the loan officer, you are the first line of defense to catch a red flag. You're also going to be the point of contact for the borrower going forward, so it's important to have a knowledge and have some idea of what's in the loan file and to spot any issues if you see them. So the first step really is organization of key documents. Generally, most commercial loans, either they're a C&I business type loan or they're a real estate loan. There are other types of loans, but those are the two main categories. And depending on what type of loan you have, you should go through and do sort of an itemization. We have actually provided certain due diligence kind of check the box list of documents to ensure that files are complete. It's almost like a closing checklist. But you want to look for things like the loan agreement, the security agreement, any promissory notes, personal guarantees, corporate documents such as resolutions and any other documents that give the corporation authority to have entered into loan transactions. If it's a real estate loan, you want to definitely look for mortgages and assignments of rents. And then also for personal property collateral, you want to make sure there are UCC filings. And once you organize this list and you organize documents, again, while legal counsel will probably do a deeper dive review, reviewing the loan documents from a bank officer's perspective is important on a few levels. But first of all, generally, when a loan is transferred to Workout, some sort of summary, most banks provide a written summary of what the loan is, what the collateral is, what the exposure is, and other key information. What you want to do as the loan officer when we first get this transferred credit is you want to go over that summary. You want to know who the key parties are, who the guarantors are, who the borrowers are, who the related parties are, who the decision makers are, who's the CEO, who's their accountant, who's their lawyer. A lot of times that information will tell you the type of borrower you're dealing with, type of sophistication they have. If that borrower's professionals are professionals that have engaged in misconduct in other workouts, that's also helpful to know, obviously, so we know what type of borrower we're dealing with respect to trustworthiness and veracity of their representations to us. So that is something you want to look at. That summary that's provided to you in the information that's provided to you, and sometimes it doesn't have that information, and if it doesn't, we can talk about how to get that information. But generally, there is some summary, at least, of what the deal of this loan is. What are the deal points? And then you want to take those deal points and you want to say, okay, we believe we have a mortgage on property A, B, and C. I should have 3 mortgages for A, B, and C. If it's a business loan that has titled equipment with certificates of title, well, there should be somewhere in this loan file where I have all the original certificates of title. And so when you know, this exercise has 2 points. One, it will give you the information you need so that you can speak intelligently about the general aspect of the deal and who the parties are and what the deal is. And secondly, if there's obvious problems in the loan documentation that's not reflecting the summary that you've received as to what the deal should be, you can be the first person to point that out and to bring it up to internal management and or legal counsel once they're hired. So on the slide, you know, there's some other suggestions as to once you've organized the loan documents, you've compared it to the summary, what other things you might want to look for. This may seem very elementary, but have the documents been properly executed? I can't tell you how many times this step where the legal names of the entities are not signatories on the documents. Instead, some, you know, doing business as has been listed, and so the documents have questionable enforceability. You know, it's always important to check and make sure the legal names of the entities that are your borrowers or your guarantors have signed correctly and are identified correctly in your loan documents. One of the second issues that we have seen come up is notaries. There are a lot of, you know, real property documents. Any transfer and interest of real estate in a loan document requires notaries. Have they been notarized? If not, that is something you should flag. And are there missing signature pages? This is also an issue sometimes in today's day and age with counterpart signatories. A lot of times, you know, if there's 5 or 6 signature pages, you know, page 3 is missing. Now, that's something, again, to flag as a potential issue. The next thing to look for, and again, this enforceable cognate provisions, this is especially in states like Ohio, where we have cognate provisions in loan documents. Those of you who have ever exercised on a cognate provision understand the huge leverage these provisions give a bank if it has to exercise its rights and remedies. A cognate provision basically is a provision that allows the bank, without the borrower being able to defend the action at least immediately, to go into court in that same day or that same week and get a judgment without having to deal with the defendant even being able to file an answer. And that leverage, to have that leverage, is a huge strength that the bank has if they're drafted properly. If they're not drafted properly, or as we'll talk about a little bit later, if originals are missing, that's something we want to know, because again, later when you make a decision, when the bank makes the ultimate decision, whether it wants to restructure, forbear, or exercise its rights and remedies, it's very important to know in states like Ohio, do we have cognova provisions, and are they drafted appropriately so that we can enforce them? The next issue is collateral or perfection issues. This is also a very significant issue, because in a workout, generally, if the bank is going to go a liquidation strategy, or if it's going to decide whether or not to do a liquidation strategy, it's normally going to be looking to its collateral to realize and monetize its return. And so if there are any issues that, in your review of the file of the security agreement and the UCC filings, if you see something in the security agreement, like this is supposed to be you're supposed to have as security for this loan all business assets of the borrower. But the security agreement or UCC filing just says business equipment. Well, that should raise an alarm in your head that something, there is an issue here. We may not have all the collateral we believe we should have. And again, dovetailing into this point, are there any missing documents? Well, cognova documents, in most counties, to enforce them, you need the original blue ink, wet ink signature page of the borrower. You need the original. So getting the original documents in the loan file are key for a full review. If you are in a state like Ohio where you are looking to enforce a cognova, the originals are key, and you want to make sure you have those so you can make sure if you want to exercise that remedy, you will be able to. And that also goes for certificates of title with respect to any titled equipment or vehicles. You want to make sure you have those originals, and those aren't missing. We've had situations before where we have clients that have a security agreement covering all equipment of the borrower. The borrower could be some sort of landscaper, and they never took possession of the original certificate of title for all the equipment that secures the loan, and that can end up costing the bank millions of dollars. And it definitely affects the strategy if you have or don't have those types of original documents. That also goes with UCC filings, as we've discussed previously. Is there something missing there that you need to shore up? If there is something that we need to perfect because there's a defect in our perfection, well, a forbearance agreement is probably a better strategy for us in a liquidation generally if we need to fix our collateral position. And then there's other things like financial statements of the borrower and guarantors. Do we have current financials? That's important, obviously, because we need to know what's our collectability of those parties for assets that we don't. What assets do they have that we could possibly collect on to get fully paid out of this loan? And it's something to, again, check the box if we do or do not. If we don't, we obviously are going to need to get those or attempt to get those documents. The next thing here we have is identify material communications. I always find that, especially in this day and age of texting and emailing, when credit is transferred from the relationship manager to the workout officer, there's normally quite a few communications that have gone back and forth. And it's important for you as the workout officer to have all those documents. You need to see the complete picture. You want to know the tone of the relationship. You want to know if there's been any statements that have, potentially bound the bank to, something like an extension of the loan or committed the bank to some sort of strategy with the borrower or agreement with the borrower to move in a certain direction. You want to collect all those communications from the prior bank officer. Just make sure you have a complete understanding of what has happened and transpired and that there are no surprises. This dovetails into the next point. Besides just getting those material written communications, it's important at the point of transition of the loan file to discuss the loan history with the relationship manager who had it before you. This is important for a number of reasons. One is in workout, many times, especially in a liquidation scenario, there's a chance the case is going to be, there's going to be an issue that perhaps is going to be in front of a judge or a mediator or some sort of court, and the borrower is going to talk about the history of the relationship. Well, it's not enough for us to say we just, we got the loan file transferred to us. We don't know about that past history. We just know from the date we got the loan file. That's generally not a very compelling argument to make to a judge that we just don't know. What we want to be able to do is speak robustly about the issues and, speak intelligently. Again, we are one institution, and the fact that a prior person handled the file before we got it should not preclude us from speaking on behalf of the institution intelligently and fully about even when the file wasn't with us. So it's one of those issues that you want to go over the relationship with the relationship manager. Sometimes there's not going to be much of a story to tell. Sometimes there's going to be a very long story to tell. And the longer the story, the more important it is to understand the details and to make sure you get a whole picture of what has happened and that you can speak intelligently both with the borrower and with any third parties for that matter about the relationship and what has happened. And the next issue is causes of customer distress. It's important to understand what has led to the credit going to workout. We've had situations where, customers have gone into distress because the industry's been impacted. We've had obviously a lot of credits that we've seen over the years where this borrower is just mismanaging itself. And it's important to understand what's exactly causing the distress to see if there's any chance eventually of rehabilitation. Sometimes, it comes down to simply, pricing and too many employees at the facility of the borrower, and with the right consultant, a turnaround is very likely. And we've seen that before. So it's very important to try to drill down and understand from our relationship with this borrower, what do we believe has caused the distress, and what is the customer's view of that as well. With respect to lender liability issues and potential claims, this is also important to know. Has the borrower, or could the borrower make any claims against the bank for any type of lender liability issues? I think most borrowers, when they're in workout, are obviously salty about the relationship with the bank, but sometimes, the three areas where we see potential claims turning into maybe even viable claims is when borrowers bring to the table that, hey, we were made some oral promises by our relationship manager. We were told we were going to get, these are examples of what we've heard before that sometimes put us in a very difficult situation. We were given a 90-day extension by our relationship manager, and that was made orally. I do know there have been banking institutions that one time had policies where they did give oral extensions on maturity dates. And so, that is not something we would ever advise a bank doing, but if your bank or a relationship manager calls you as you're discussing the relationship, yes, we did discuss it, this is something that did happen, that's a very important, obviously, for you to know. It's also important for you to try to find out what the loan officer's relationship is with this borrower. Are they friends? How long have they known each other? Those types of things. We've seen that sometimes create an issue. We've seen sometimes the relationship close on just a business level where the loan officer has provided advice to the borrower about certain things, about how they could turn around their business. That's important to know because that skates near the edge of where some of these lender liability claims come from. Finally, on the lender liability issue is you want to look sometimes, this is very rare, but it does happen every now and then, of badges of a rogue loan officer. When we say a rogue loan officer, what we mean is when you get this relationship, you see things in the file that are truly outside of policy, meaning credit was extended without going through committee approval. Certain things that just, extraordinary actions taken by this loan officer on their own without anybody's knowledge or approval. And when those things happen, those tend to be some of the most difficult workouts because the loan officer, obviously not acting under bank policy, puts the bank in a very precarious situation now that's looking to collect on that loan. So those are things to also look for. And the last thing on this slide is getting an understanding of any litigation that the borrower is currently in, whether if that's with any of their customers or any other competing creditors. A lot of times, obviously, if a customer is in distress with us as the bank, they have other issues. And it's very important to know what litigation is out there, what other unsecured creditors or other banks are chasing this borrower, if any. Do they have any taxing authorities that are coming after them? And taxing authorities should always raise an alarm bell in our heads because they can prime our lien. Construction projects are another area that you want to look at and make sure that you have a full understanding of what creditors are out there and what litigation is out there in that arena. And the next step, once all the documents are reviewed and we've gone through and we've got a really good understanding of where the relationship's been, where we're at, the question is, do we want to meet with the borrower? And it really depends. I think there's a lot of good reasons to do it, especially if you're looking to do some sort of forbearance or restructure, or we know we have some holes in our documentation that we want to fix, and there's strategic reasons for us to, do a restructure or do a short extension on this loan. Then it makes all the sense in the world to meet with the borrower. Even, in a situation where you're most likely going to do some sort of liquidation and exercise your rights and remedies, I think the pros to meeting with the borrower is they get to tell their story. And I think many times, and I think we can all relate to this, there is a human aspect to all of this. I mean, this is the borrower's life. And so there's something very therapeutic to being able to speak face-to-face with somebody and at least share your story. And if they at least hear that we're sympathetic and, this is nothing personal, even if the relationship turns to one where you're liquidating the business, it can still be done on good professional terms, and sometimes meeting with the borrower can help establish that. The one instance in which I don't think it makes sense to meet with the borrower is when the borrower has committed fraud, the borrower has committed is somebody that we just simply do not trust, will not trust, and, meeting with them is just going to turn into, something unproductive and a waste of time for the bank. Though we've had situations where, we've tried to take the high road with some of these folks, and it turns into a no good deed goes unpunished scenario where it just creates even more friction. And so if you're dealing with bad actors, bad people, that's one situation in which, we would not suggest meeting with the borrower. And then one of the other pros, which I think is a good bank officer can do in meeting with the borrower, is you can really get a lot of information that hasn't been conveyed by the relationship manager and hasn't been conveyed in any of the loan documents from speaking to the borrower directly. And the more you let them speak, the more they'll explain their story, the more they'll explain about potential sources of extra collateral for us. They'll give us some really beneficial information in that meeting that we would not have otherwise have had. And that is something that can be very positive and help us in a restructure because we now have the benefit of that information. And then finally, in meeting with the borrower, it gives the bank the opportunity to establish ground rules with the borrower. Again, the human component, explaining to the borrower that we need them to be honest, we need them to be transparent, we need them to be proactive with all communications going forward about their business, about providing financial information, and that we expect no surprises, and that we can only react to their situation if they're following these ground rules. Now, we're not making any promises that we're going to do a restructure or extend the loan, but these are the basics to which the opportunity to do one must be met, or there's not even a potential for a workout if one of these ground rules are not followed. And then lastly, in this section is communicating with the borrower. We want to make sure.
Bryan, if I could just jump in with one word of caution to convey to the group before we move on to the next topic. In some instances, early on when loans are transferred to workout, the handoff between the line and the workout is not clean. And in some instances, you still have line officers being involved with the borrower at the same time as the workout loan officers. One thing I think workout officers and officers in general need to take care of is when you're meeting with the borrower, you need to remember that you're one bank and one voice. So you need to make sure that the line guys and the workout guys are conveying the same message to the borrower. Bryan, I'm sure you and I have both been involved in instances where sometimes messages are mixed and it creates for some confusion. So, I think that's just one point to think on early on, who's conveying the bank's message and to make sure that the message is consistent.
That's a great point, Carrie, and I'm glad you brought it up, and it's one that yeah, there really should be one voice, and once it's transferred to workout, I think the general rule at most banks is it's the workout officer and the relationship manager should step aside as far as communicating directly with the borrower. And if that's not the case, whatever institution, whoever the institution wants to be the point of contact, there should be just one point of contact. And then communicating with the borrower. So some of the practices, and one of the things we want to convey is that your communications should be unambiguous with your borrower. Crystal clear communication, whether you're, especially when you're talking with them, you need to always let them know that, you're not making any promises or commitments on behalf of the bank, unless obviously, you've reached the stage where you're putting things in writing, you're documenting actually signing the documents, that, you're gathering information. In most situations, any proposals, management's going to have final approval. And if the workout officer, is as much as, you're not there to hurt the borrower, you're working on behalf of the bank, and you're there with a duty to the bank to obtain this information, be professional, and being clear in your communication that you're not making commitments that you don't want to be making is very, very important. And the next point really, drives that home is any conversations you have, whether it's the phone or in person, you should always confirm what's the understanding of, what happened during that call or during that meeting. And that will keep the record clean as you go forward. There's no he said, she said later. It just really protects the record that, we met on such and such date. You agreed you're going to provide us with X, Y, and Z. We are still, reserving our rights and remedies. And after we look at this information, we will get back to you. Something to that effect is what you want to put in writing. So it's absolutely clear that no commitments have been made on behalf of the bank. And later, if things go south, your borrower can't point a finger and say otherwise. If they do, you'll have this confirming email or confirming writing that will show that that was not the true intent of what was said at that meeting. All things being equal, we are lawyers. We do prefer that you communicate with your borrowers in writing. We understand, again, the human element that can't always be done, and sometimes you will have to talk in those situations, and talking on the phone or in person is helpful sometimes. You just want to confirm those in writing. And then lastly, this is just a rule of thumb, and don't ever break it, is stay professional. And in workout, that is sometimes very difficult because borrowers will yell at you, they will call you name, they will be very aggravated, promises will be broken, but your job is to represent the bank, and you, in that capacity, it's very important that you remain professional at all times. Anything you say or put in writing, just picture if that was published in the newspaper and your name was attached to it, would you be proud of it? And that, if you wouldn't, then don't say it and don't put it in writing to the borrower, because it's just going to come back to hurt you at a later point. And with that, I will transfer this presentation over to Carrie Brosius.
Yep, Bryan, I also just wanted to follow up on your last comment. It's easy for us to be cautious when about sending negative emails, so it doesn't look like the bank is, placing a bad foot forward. But sometimes, and I've dealt with instances where the bank officers get along with the borrowers and they get chummy, and sometimes they get too chummy and they pass along a joke, or they pass along something at the time everybody thinks is funny, but then it ends up as Exhibit A on the screen. So not only be cautious when you are conveying messages that have you're responding to something negatively, be cautious when you're just generally responding, or if you think you're just, sending a casual email. If you don't want that email to be Exhibit A in a litigation, just don't send it. So moving on, early on when a loan is received into workout, one of the first things you need to give consideration to is, are there any type of notices that the bank should send out? And usually there is a notice of some sort that is required. The first thing to think about when sending out a notice is where and how should the notice be sent. Look at the terms of your loan documents, or your attorneys will look at the terms of the loan documents for you. The loan documents will identify who is required to receive notice and how notices are to be sent. In some instances, notices to borrowers may have to be directed to multiple corporate representatives. Other times, counsel is entitled to notice as well. Some loan documents require notice to be sent via overnight mail or registered mail. Other times, email notice will suffice. it's important to take care that the notices are being sent to the correct individuals in the correct manner. Later, down the road, when the bank decides that it's necessary to exercise its rights and remedies, a defective notice that went to the wrong party or to the wrong address or in the wrong manner can come back to haunt the bank. It may impede the bank's ability to exercise certain remedies. In other instances, it may even prohibit the bank from exercising remedies when proper notice was not conveyed. Now, one of the more popular, and almost always it's a good idea to send, is a reservation of rights letter. Now, a reservation of rights letter will provide notice of an event of default. It notifies the borrower that the default is not being waived, but the lender is reserving all of its rights as it considers what course of action it would like to take. Within these letters, take care to specify that in sending this letter, it does not necessarily mean that the bank is going to send a second letter once it chooses to exercise a particular right. You also should take care within these letters to note that any partial performance that the bank may accept does not result in a waiver of the default or a waiver of the bank's right. Another popular letter is the cure letter. Often the loan documents will provide a period of time in which a borrower may cure a default. Typically, the cure period is not even triggered until the lender sends the borrower a written notice of default and demands a cure. Once again, take care to note that the bank is reserving all rights, including the right to take action before the cure period ends. In certain circumstances, cause may arise where the bank will need to take steps before the cure period ends. Examples would be if a new non-curable default occurs, or if your collateral is in jeopardy and immediate action is required. You do not want your correspondence to restrict your actions if the landscape changes. Once again, it's a good practice to note you're reserving all rights, that you're not necessarily required to send a notice again, and also that you're reserving all rights in the event that you accept partial performance. Notice of default interest. Following the occurrence of an event of default, the loan documents typically allow a lender to institute a default interest rate. On occasion, the loan documents will require notice. More often than not, the loan terms will provide that notice is not required before imposing a default rate. However, as a practice pointer, providing an unnecessary notice of a default rate can be a good way to gain the attention of an unresponsive borrower. If you've been trying to gain a borrower's attention, sending them notice that you're increasing their interest rate often will lead to a phone call and may start the communication. Again, I know I'm a broken record here, but when taking this notice, you need to take care that you're reserving all of the bank's rights and that you're not going to waive any rights. And finally, another popular letter is the acceleration and demand letters. These letters provide notice of the acceleration of the debt and will demand immediate payment or payment within a date certain. Now, prior to sending this letter out, be absolutely certain that you have an event of default and that there is no applicable cure period. And if there is a cure period, you provided the required notice and the cure period has passed. These notices should identify the specific default. They should state the exact amount owed with a per diem and payment instructions, or alternatively, they should provide specific instructions on how the borrower may obtain an accurate payoff and make payment. Demand may be immediate or within a specified time period. And of course, the letter, as always, should note that the bank is reserving all rights, including the right to take action before the expiration of any time period that may be stated within the letter. And once again, particularly when you have accelerated the debt, you want to make note that partial performance, that if the borrower cures and makes that one monthly payment that was missed, the acceptance of that monthly payment isn't going to result in a waiver of the default or a waiver of any of the bank's rights. And in addition to assessing what type of notices the bank should send out to protect its interest, often it's a good idea to order various lien searches to ensure that the bank's security interest is perfected, to determine the priority of the bank's security interest, and to identify any lien interest that may affect the bank's interest. A very popular search that I'm sure everybody's familiar with are the UCC searches. These searches identify all creditors that have an interest in the borrower's personal property assets. While a lot of states will allow you to search UCC filings online, such searches are not guaranteed to be accurate. To ensure that you have a complete and accurate search, you need to order the search from a service or directly from the Secretary of State. UCC searches will confirm whether the bank has properly perfected its security interests. It will also identify other creditors with security interests, their priority, and what assets may constitute their collateral. UCC searches can be a good tool to help the bank spot difficulties or areas of concern. For instance, when the UCC search comes back and you see a series of assignments where the borrower has assigned its interest in its accounts receivable, or you see an assignment to a company that appears to be a factoring company, this should set off alarms to you and trigger an inquiry. The presence of a factoring company usually is not a good sign. At a minimum, it means that your borrower is having cash flow problems, and it could even mean more significant problems. Additionally, if your collateral primarily consists of the AR, it's a sign that someone else is likely collecting your collateral that you may have been relying upon when you moved into collection. So UCC searches can provide a wealth of information. As a practice tip, UCCs are very specific. So when you're ordering your searches or conducting the search yourself, you need to be sure that you are conducting that search with the borrower's exact legal name. A good place to pick up the to make sure that you're utilizing the borrower's correct name is to look at the borrower's articles of incorporation. A number of states will allow you to look at copies of the articles of incorporation online. I know that Ohio is one of them. So just keep that in mind when you're ordering your UCC searches. Filing or searching under the incorrect name doesn't do you any good. And when I say that they're extremely specific, if your company's name is ABC Holdings with an S LLC, and you search or file under the name ABC Holding with no S, that type of search or that type of filing is going to be insufficient to ensure that you are properly perfected and to ensure that you have an adequate research that you can rely on. Other searches that can be beneficial include title searches and judgment lien searches. These searches will identify junior mortgagees or junior judgment creditors that may commence to exercise their execution or collection rights. A junior creditor, a junior lien holder, a junior mortgagee may become troublesome to the lenders if they attempt to execute on the borrower's assets or disrupt a borrower's ability to conduct business. Tax lien searches. Depending on the type of search that you run, it's not necessary. You cannot depend on tax liens to necessarily show up on your judgment lien search or on your title lien search. So when you order those searches, you want to specify that you're doing a tax lien search as well. Tax lien searches will identify any liens filed by the IRS or the Pension Benefit Guaranty Corporation. While such liens do not prime a lender's interest in existing collateral, these liens will prime the bank's interest in assets acquired 45 days after the lien is filed or within 45 days after the secured party's notice, which is ever earlier. So if your collateral consists of accounts receivable, receivables that accrued 45 days following the lien filing will no longer be subject to the bank's first priority lien interest. The IRS or the pension fund will have the first priority interest on all ARs that accrued following the 45-day mark. Additionally, the IRS and the pension liens will be superior over new loans that are extended by the bank following the IRS filing. So even though your security agreement provides that the collateral secures any and all obligations, including those that may arise after the fact, once that IRS or that pension fund files a lien, if you extend a new loan, whether it's a complete new origination, or in some instances there's been some interpretation that a new loan could be just a draw on a draw note or a draw on a line of credit, you need to take care because those new draws, those new loans they are going to be secured by a lien that's junior to the IRS lien and the Pension Benefit Guarantee Corporation's lien. Thus, obtaining a federal lien search can be a huge benefit to the bank, particularly if you're considering new loans, you have outstanding draw notes or lines of credits, or you're relying heavily on accounts receivable as your collateral. In addition to conducting lien searches, there's a few other due diligence items that a workout officer can do to arm itself and make itself a little bit more knowledgeable of the borrower. One of those items would be a credit report. Most of you are probably familiar with credit reports. They're going to advise you whether the borrower is generally paying its bills, whether it's tardy, whether it's running into issues with its suppliers and vendors. Often these credit reports, whether they're consumer or they're commercial, like Dun & Bradstreet reports, they will provide you with a credit score to help you evaluate the borrower in relation to others. Property reports are always a good idea to order, particularly if your financial information is dated or it has been a while since you've received a personal financial statement from a guarantor or an individual. Additionally, the asset reports will allow you to double check the accuracy and the truthfulness of the information given to you by your borrower. These reports will identify real and personal property or certain personal property owned or previously owned by the borrower or guarantor. This will allow you to identify any additional collateral that the bank may acquire. It will also identify possible fraudulent transfers that may be unwound for the lender's benefit. Now, the personal property listed on such reports is generally limited to registered assets or assets with certificates of title. Examples include vehicles, trailers, boats, and aircraft. And finally, another search to consider would be a litigation search. These searches will not only identify judgments, but they awarded against or in favor of your borrower, but they will identify cases pending against your borrower. While pending cases against a borrower are contingent liabilities, it's important for a lender to inquire about them. The amount at issue or other factors may greatly impact the lender's risk assessment. For example, if the borrower is on the cusp of a trial or the borrower is facing a multi-million-dollar claim, it may impact the lender's collection or forbearance strategy. Similarly, a lender may want to reconsider its course of action if it learns that the borrower is facing a long, drawn-out piece of litigation, or the borrower is facing several smaller cases, both of which may divert the attention of the borrower's management or take up resources and negatively impact a borrower's business or its financial performance. And one thing to note when you're ordering these litigation searches, you should take care to order not only federal, state, but also local courts. That's pretty much concluded our initial notes pertaining to loans and things to consider when they move into workout. Bryan, unless you have anything to add, I thought we could open the floor up to questions.
Yeah, we do have, and people can use their write-in questions in the question tab. There were a few that came in that the first question that we have a couple questions, so please feel free to send further questions if you have them. But the first question we had is, do you have any current concerns with enforceability of cognovits if a borrower files for bankruptcy? Well, the cognovits enforceability doesn't depend on whether or not the borrower or guarantor files for bankruptcy, so the enforceability of a cognovit is going to stand on its own. Obviously, if a borrower or guarantor files for bankruptcy, there is the automatic stay of bankruptcy, which you can't take any collection action. So taking a cognovit would be included in that, so you would not be able to take a cognovit without getting relief from the stay. Do you have anything to add to that, Carrie, to that question?
Well, just in the event that the person inquiring was concerned about whether a cognovit provision is something similar to receiving a security interest or some type of benefit that could be avoided as a preference or a constructive fraudulent transfer. One thing to keep in mind that would not be the case, even on an academic level, because, when the cognovate provisions being signed, they're being signed with the note. So the bank is conveying consideration at the time that it's receiving the benefit of the cognovate provisions. So it not only would the bankruptcy not affect the enforceability of it, but it also most likely would not be an avoidable provision.
Right, and the one thing, obviously, in bankruptcy, if this is the questioner's concern about a preference or something like that, sure, preferences are, a preferential transfer. If the cognovate gave you a judgment lien and the borrower files for bankruptcy, 30 days later, it, on that level would be treated like any other judgment lien and it would be a preference. But standing alone, I don't think bankruptcy would affect enforceability, as we've stated. The next question we have is, how do we obtain email correspondence if we can't access that easily? I assume this question means from the prior loan officer handling the loan. That sounds like that would be an internal issue. All of the bank's correspondence should be saved, and should be saved on a some sort of system under a file, which is they're not being deleted, on a regular basis. If they have been deleted because of some automatic deletion policy at the bank, that's something probably we need to speak, that's a private conversation about that IT issue and whether or not, that should be happening. Do you have anything to add to that, Carrie?
No, I would just reiterate what you had to say, Brian, is, for each particular bank, my experience has been is typically your in-house legal counsel is the starting point of how you can access email, from prior loan officers or even loan officers that are no longer with the bank. They are usually your starting point. So if you're running into difficulties, that might be the place to start.
At this time, there are no more questions. We would like to thank you for joining us today. Should you have questions after our call, please feel free to reach out to Bryan and Carrie directly. This concludes our program.